The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 3 cases that will be submitted. Those cases are Lori Freeman and others versus Grain Processing Corporation, State of Iowa versus James Shorter, and State of Iowa versus Yarvon Russell. The Russell case is now submitted to the court without an oral argument, and we'll hear now the arguments in the Freeman matter. Mr. Reck.
Your Honor. May it please the court, I'm Mike Reck with the Bell & McCormick Law Firm, and may it please counsel. I'm here with Kelsey Knowles, also of the Bell & McCormick Law Firm. We thank you very much for your time here today to hear what we believe is an extremely important case on the appropriate parameters of class litigation in the state of Iowa. We are no longer writing on a clean slate. We are seeing more and more litigation in this area, and those parameters are being drawn further and further. We've certainly seen at the U.S. Supreme Court level numerous cases in that regard. This case involves 8 Muscatine residents trying to prove GPC's air emissions reached nuisance levels and had nuisance effects at every property in a 1.5-mile radius from GPC, at least those within the state of Iowa. You are asked to decide today whether in a case where it has been found that class representatives cannot prove liability class-wide, and where plaintiffs cannot show, their own experts indicate they cannot show emissions that would even be perceptible class-wide, whether it is permissible to use unidentified, unvetted class representatives for smaller class areas to prove liability, and to do so with what they call a concentration total model, whereby they add disparate elements, all with different perception thresholds, and then treat them all the same. You're further asked whether that's appropriate with regard to a cause of action, nuisance, where this court has held repeatedly that each individual property must be examined individually. It is not what GPC does that matters for purposes of nuisance. It is the effect on that individual property.
Well, aren't there some Go ahead. Well, it's common in class action litigation to have individualized questions of proof on damages. It happens all the time. Sometimes there's common issues on damages, and sometimes there's individual issues, and a combination of both, frankly. But on the question of liability here, I mean, the claim is, at least as I understand it, that the equipment was dated, was not well kept up, et cetera. These are allegations, of course. I'm not taking anybody's side, but I mean, the position of the plaintiff is that there was equipment that was operating poorly, GPC knew it, and that it was causing these emissions that led to various harms. And of course, on the class certification stage, we're not adjudicating the merits, but the question I'm posing to you is there a common issue with respect to whether or not this plant was spewing out alleged pollutants, and is that not enough to support a district court's judgment that we should proceed with class action?
And Your Honor, if that is a common issue, then every single case involving a manufacturing plant and emissions is appropriate for certification. Because indeed, every plant of this sort will put out emissions. Indeed, those emissions are reported annually, tons of them, and that is not a factual dispute in this case. But, Your Honor, I guess what I would ask you, and I know I don't actually get to do that, but rhetorically I would ask you, is what does that prove for 2209 New Hampshire Avenue, New Hampshire Street? It proves nothing. And the reason it proves nothing is because it depends on what reaches that particular property, the effects on that particular property. There is a balancing under nuisance law that balances several factors. And indeed, one of those factors is not particularly the conduct of the defendant. The defendant can either walk with the angels or dance with the devil, and they may or may not be a nuisance, right? Because it is not what they do that determines what happens on 2209 New Hampshire.
I agree in part with you. I mean, as I understand it, I mean, the class is 1.5 miles, and there's going to be topographical variations and whatever. And just for our discussion, let's say that 2209 Delaware, for whatever reason, was in a cul-de-sac and didn't suffer any pollution that you're able to show that. And there may well be pockets. But once again, isn't that kind of common in class action too? I mean, the mere fact that there are some members of the class who may not qualify for damages is not ordinarily considered, I don't think, a disqualifying factor. But I want you to push back, of course.
And Your Honor, I would agree with you that damages are not typically enough to refuse to certify a class. But this is far more than damages, because nuisance involves a balancing to determine whether there is liability. All right? And so when you look at it, you would have to determine for each property the balance of the priority of the location, the nature of the neighborhood, and the severity of the interference. Those are the elements that the Perkins case tells us are important. And what I would point to, Your Honor, is going to the Perkins case, which we believe is the most important case. It was basically an air emissions case. The conduct was identical in that case, 100% identical. It was figure-8 racing at a fairgrounds. And indeed, emissions, dust and particles, made it to every single property. So the conduct was identical. Everybody was touched with emissions, and yet this court held only one of those plaintiffs could recover, because liability, Your Honor, was not determined commonly. So what you would have to do, you could say, well, all right, I understand, Mr. Reck, there are some issues, and we agree we can't mask those issues. I think we'd probably all agree you can't mask individual issues for the sake of certifying a class, because that would implicate due process. But maybe we could defer those for later on. That is not what this court did. This court, in fact, said it can try all of them commonly by choosing individuals throughout the class area that will represent their areas, which have different, what they call concentration totals. And people within a perimeter near that individual representative, who we don't know, right? It's been unidentified, unvetted, which we've already noted in our papers, we believe is a constitutional due process issue in and of itself under Hansberry versus Lee. They are then going to use that person with their concentration total to say that little area has a nuisance. That can't be done. It can't be done.
Mr. Reck,
Yes.
I mean, my general understanding of class certification is it's easy to get in cases like antitrust or securities fraud, where everybody is going to have the same liability if they're a class member, the same ability to recover, and the damages are kind of a mathematical computation. How much stock did you own? How many computers did you buy? So forth and so on. On the other extreme, I know that personal injury cases really aren't suitable for class certification, the U.S. Supreme Court has said, because everybody's injuries are kind of different. It seems to me this is somewhere in the middle, and they have at least a theory that allows a commonality of recovery, with that being based on their experts' analysis. And why isn't that theory, where you add up the numbers and the particulates and all that, why isn't that theory one that they're at least allowed to proceed with? And then at the end of the day, if it doesn't work out, they lose.
So there are a number of answers to that. One, you are absolutely correct. Antitrust is the epitome of what is certifiable. And the reason for that is you're looking at injury to competition, not injury to competitors, right? What's different here is you must individually look at each property. And Justice Mansfield, what I would say about why they can't do that is it's not only prejudicial to GPC potentially, but also absent class members. Let's say there is somebody who is truly damaged in a particular area, but this person can't prove it. This person's going to lose, right?
Is this an opt-out class, though?
You do have the potential to opt out, Your Honor, but that assumes a lot of knowledge by individuals that they may not have in terms of the liability. But nonetheless, it is always critical that claims have to rise or fall with the class representatives. And if they cannot prove liability class-wide, it shouldn't be certified, even if people can opt out.
Is there a superior way to resolve this litigation than the class action?
It is an interesting question, Your Honor. I think you probably can take judicial notice of filings that have come to this court. And indeed, you have, I believe, 16 interlocutory appeals in this very case from individual plaintiffs who wish to pursue their own claims. They say they represent literally hundreds. So indeed, it appears that far more people wish to pursue individual claims than wish to pursue common claims. And that is on your plate at the moment.
Is it practical to expect individual homeowners in this neighborhood to take on GPC on their own? Are these claims too small to be viable without aggregating them as a group?
Apparently not, Your Honor, because we do in fact have them saying that they are bringing 200-plus individual claims. And as I say, that issue is, there's an interlocutory appeal that just hit your desks, I believe, last week on that very issue.
Is the case subject to CAFA? I mean, in other words, are they below the limits? I mean, I would assume there has to be some diversity somewhere in the case, right?
As I recall, and the answer is no, I believe, because they have limited their class to only Iowa residents. And I believe CAFA, you have to cross state lines. But going back to your question of a moment ago of why they can't just add disparate substances, it is impermissible under current law to mask individual issues. And it is the case that all of these things they add volatile organic compounds, VOCs. There are multiple things that are VOCs. They all have different perception thresholds. They also then add to that SO2, which has an extremely high perception threshold, and particulate matter of 10 microns, which may not have any odor at all. They then add them together and treat them all the same, even though they admit they are in different proportions. That does strike GPC as the definition of masking individual issues. How is it that you can do that with that model? And, Your Honor, you asked the very salient question, should they be able to do that and just see whether it filters out in the wash? Behrens versus Comcast tells us no. Behrens versus Comcast says you must critically look at that expert report and say, does that make sense? And
Well,
so,
but
yes.
I'm interrupting you, and I'm sorry.
You have that right.
But, and I want you to finish your thought if I've poorly interrupted. But the district court is closed with discretion here. Everybody, I think, sees that. And there's never any kind of perfect class action, frankly, ever, I don't expect. Why should we declare that abused its discretion when, you know, it engaged in, you know, frankly, the balancing that we're talking about today? If it turns out that the balancing was wrong, you can always decertify, of course, and it happens with some regularity. Shouldn't we defer to the district court's judgment on this and allow things at least to proceed to some extent?
Abuse of discretion still is a standard review, and indeed there is automatic right to appeal of these issues precisely because they are so important. Further, Your Honor, I would suggest to you that there are, certainly the balancing in and of itself is subject to abuse of discretion. It's far less clear that when we're talking about due process issues, which are constitutional, that is not a de novo review. And what we are saying is, indeed, they are when they add disparate elements that are all different with all different perception thresholds.
Actually.
And so I think you have de novo review of the issues that we are raising in particular. You'll note that we did not particularly try to revisit the balancing. What we said is there are a couple of things that are clearly wrong here. You do not get to say that our class representatives cannot prove liability class-wide, so we're going to pick unidentified individuals to carry that burden elsewhere. That's not only unfair to GPC, but other people in that area. Remember George Ruckles, right? George Ruckles is the only person who actually had his emissions tested because he was so sure they were from GPC, bug droppings.
Oh, wait, I'm a little confused by that argument that you've made in the brief that there's a denial of due process. It seems a little odd, this notion that having other people come in and testify denies due process. I mean, the real issue is what the court does with the testimony. And I don't read their position as being that this relieves them from proving up liability on behalf of the named class representatives. It's just additional proof in their case. And what's wrong with that?
Your Honor, they actually said that liability will depend on what those individuals show, and that is in fact what the district court held. So could you have supportive evidence of this person says, I was at their house too, and it smelled bad at their house? Absolutely. There's no contesting that. But can you have an unidentified representative to say, yes, conditions are different here. They're not the same as the class representatives area. They're just not. They are lower, and in fact, it may not even be perceptibly because that's what their model shows. But I, unidentified witness, am going to prove liability for my area. And the reason it's a due process issue is Hansberry versus Lee, right? Because liability rises or falls based on that individual's claim. Now, Your Honor, what happens, in our minds, the critical question is what happens if that witness in that area with different conditions does not prove a nuisance? Who loses? Everybody?
Should we follow the Eighth Circuit decision in Ebert versus General Foods that came down after the district court certification?
I think that's going to be my easiest question to answer. Yes. We certainly think so. Ebert, we think, is on all fours with this case. It indeed involved this very issue, and they looked at it and they said exactly what I am saying to you. They didn't have Perkins guiding their analysis, but what they said is, oh my heavens, that is going to vary property by property. You've got an inherently individual balancing, and to your question earlier, Justice Apple, doesn't it matter what happened on that property? In Ebert, there is absolutely no dispute. They buried 1,000 gallons of toxic substances on that property every year. They danced with the devil, all right? But there could not be a common finding of liability because it depended on what happened on that property. Ebert is on all fours.
I don't know if I agree with that. But let me ask you this, if I may, and I see your time's out.
Me too.
But is it your position that nuisance claims necessarily cannot be class actions? And if not, what is, I mean, I understand your due process point, by the way, but what is it about this besides your due process point? And I don't mean to minimize it, but what is it that makes this particular nuisance unamenable to class actions if you don't have a across-the-board rule?
Sure, and it is an interesting question, right? We have certainly pointed to the Perkins case and said that requires individual examination. And we could look at Nebraska.
Not in a pollution case, I don't think. I mean, I don't read Perkins quite, I mean, I want to have the dialogue with you. I don't quite read Perkins that broadly. There's a lot of pollution cases out there where class actions have been certified. And I'm just trying to figure out, you know, kind of where this line is drawn.
And I do want to answer. I assume I have your indulgence to do that, given that I've already run over. This is the first time I've only gotten to the first page of my outline, I might add. It is, you can anticipate what I am going to answer, right? Is it possible that there is a case that could be certified? It's hard for me to answer that standing here today, to envision one. But I think if you started walking back from certain elements of this case, you could get closer, right? If you had a one-time event, right? This is a plant that's been there since 1943 with wildly varying conditions. At one point, they were actually burning tires to power their that may sound awful, but so is the University of Iowa and everybody else. It was thought to be environmentally friendly. They've had all sorts of variations. It's not a one-time event. Could you have a situation where there, in fact, was a showing of something perceptible class-wide? We don't have that here. If you had a showing of something perceptible class-wide, you'd walk one step further over to saying it could be certified. Could they have a plant that post-dated all residents? That is typically what you find. If you look at some of the cases, all the residents live there. There's some event that happens that causes a nuisance, and they say, well, but you have that commonality. Here you have people moving to this area with all different knowledge at all different times. Becky Boiselle being the classic example, right? She knew of the smell when she bought her house. She thought it was awful in the 1950s. She thought it gave her asthma. She, in fact, moved within 400 feet of GPC 9 or 10 months before suing with that perfect knowledge, and then sued GPC. Could that knowledge, is that knowledge, first of all, Your Honor, relevant? If you were saying as a district court judge, as some of you have, of course, would you allow that evidence into the record? Would you let that in? Because it shows she knew what she was getting. If that evidence is admissible, doesn't due process command that GPC has to be allowed to admit that same evidence and explore that same evidence for every single class member? And I know you want to ask me another question from the expression on your face, but I have gone way over my time. I thank you for your indulgence. You will have another shot at me, I guess, for 5 minutes later on. Thank you.
Mr. Reck, thank you as well. Ms. Siskind.
Morning, Your Honors. I'm not even going to begin with my outline. I want to address some issues that Mr. Reck raised and a confusion that was raised. First, I want to say that there's some confusion in Mr. Reck's presentation on what we contend are our proofs of class-wide harm and what we contend we will prove when we get to the completion of a class-wide trial, and why allowing us to proceed with a great number of significant issues with our proofs class-wide in a single trial will achieve enormous efficiencies and fairness, and that Judge Rydell's conclusion to this effect should be deferred to. There are three accomplishments that we can arrive at the end of the class-wide trial if this case is allowed to proceed. The first is and we would anticipate doing this through special verdicts. The first is that GPC released smoke, odor, and haze to every property in the class, creating conditions that were offensive or seriously annoying to the Iowa law normal persons living in the subclass. In other words, that these were serious enough to constitute a nuisance. The second is that harm was experienced by the named plaintiffs and by others testifying as fact witnesses from properties throughout the class, that harm was experienced at those individuals' properties. In other words, that we will prove that the harm experienced in the class boundaries reached every area within those boundaries. It was a class-wide impact, class-wide harm was felt. The third feature of the case that we can prove and achieve in a class-wide trial is that we have a method for approximating and apportioning damages for lost use and enjoyment that we plan to propose to the jury, which will assign not to individual class members, but to each property in the class based on scientific data, taking topography and wind and weather into account, and can measure the roughly, but can measure the emissions that and concentrations that are present and how often they're present.
Here's the problem with what you're saying is I'm not sure those three things add up to anything that is ultimately determinative in the case. And that's because, as I understand nuisance law, it involves a substantial and unreasonable interference with the land, weighing a number of considerations, including whether the plaintiff actually came to the nuisance, and it also has to be a substantial interference. It can't just be an interference.
Exactly.
And in evaluating that, I mean, don't you have to look at that on a homeowner by homeowner basis?
The homeowner by homeowner examination is something that I will get to in a minute, but at this class trial, GPC will have the opportunity to establish that virtually, and this is not disputed, that virtually everyone in the class knew about the nuisance. This was an open and notorious nuisance.
But some of them bought their houses very late in the class period. Some bought their houses long before the class period.
The class period is not the cutoff, Your Honor. Virtually every class member was aware of the pollution before they purchased their homes, regardless of the date they purchased them.
Some inherited their home, or maybe, I mean, how do you get around this substantial and unreasonable, where unreasonable factors in things like, you know, who was first, the plaintiff or the defendant?
Permit me to address the priority of location issue, which is really the chief so-called individualized issue that GPC has pressed here, has stressed. The fact is, and Judge Rydell, looking at the evidence, found, and GPC in fact contended and admitted in its papers that you'd had to be living under a rock. They were quoting from a DNR field examiner. You had to be living under a rock not to know about the open and notorious pollution in this community. GPC cites claims that there is one individual that they've determined did not know. In fact, that's Kelsey Brackett, and in fact, the testimony that they cite from Mr. Brackett does not say that he did not know. He's not asked that question. He answers a different question. It doesn't support GPC's position that there was a person who didn't know. But let's assume there are some people.
Agree with that? Is that the plaintiff's position?
It's our position that this was an open and notorious nuisance. GPC describes the south end of Muscatine covered in a haze. If we had that odor, haze, et cetera, at our plant in Indiana, one GPC plant manager says we would have serious problems with the locals.
Is it your position that everybody who acquired a home took the nuisance into account when they acquired their home?
It is our position, it is our understanding of the evidence that virtually every class member that moved into the neighborhood was aware of the nuisance. That is a priority of location factor. That's a factor that favors GPC. What GPC is saying, oh, but there may be exceptions, people who didn't know. Those are not defenses for GPC. GPC wants to find the rare exception, someone who didn't know, that defeats GPC's defense. In other words, in the class trial, GPC will examine these witnesses, the plaintiffs, the 30 or so or more witnesses whom we call from around the class, and it will develop that these, we expect, we haven't identified them yet, we haven't gotten to the pretrial stage, but we expect that GPC will have plenty to work with to argue to the jury that these people, because the nuisance was open and notorious and horrific, that these people knew about it when they moved in. Why they moved in is, doesn't matter, but they've got that factor in their favor in the class trial. The idea that they want to ferret out the exceptional person who may not have known is disingenuous. It shouldn't defeat class certification because that person has, with respect to that person, GPC loses its defense of priority of location. It doesn't gain a defense. It doesn't lose. It's not masking a defense that GPC.
Why shouldn't we follow the Eighth Circuit decision in Ebert?
Ebert, first of all, was decided under the federal rules. The court in Ebert didn't follow the federal rules in evaluating whether a court has exercised its discretion properly or has abused its discretion. One factor is, did the court do what the rules require him to do? This court did not determine whether or not common or individual issues predominated in the case overall. What the court said was there are some common issues, and we're going to consider that in the narrow portion of the case where these common issues will be litigated, they will predominate. It's sort of a conclusory statement, but that's what the court did. The court did not make a predominance finding. Under federal law, even more than under Iowa law, this is a required finding. You cannot proceed with a 23B3 class under federal law without the courts having weighed the individual issues overall in the case against the common ones and come to a determination that the common issues predominate. This court didn't do that. In Iowa law, there is a weighing of predominance with respect to individual and common issues as well. Judge Rydell did that and did that carefully and painstakingly. Curiously, in Iowa law, it's not a requirement. It's one of 13 factors, but it's a requirement that the court took quite seriously and that he exercised his discretion to judge overall throughout the whole case which will predominate. And really what he considered and what he concluded, weighing all of the factors that the Iowa rules require him to weigh, is that the complexities of the case, the affordability of proceeding, the predominance of the common issues merit class certification because they will make the case's adjudication in comparison with thousands of individual trials efficient and fair.
Well, you've got a lot of individual cases on file, apparently.
We have 20 individual cases on file, possibly 25, 20 or 25, 2,000 properties in the class. We think there are at least 4,000 class members. That's not a high number, it's a low number. The court considered it as to whether it affected his determination to certify the class. The defendants raised it as an issue with respect to the adequacy of the class representatives. The judge deemed the numbers small. They did not warrant his finding that the class members were not adequate. The defendants have not appealed that ruling. It is not before this court.
Is the reasonableness of GPC's conduct at issue in a way that's common to all class members? They could have, I assume, replaced their dirty coal-fired dryers with the cleaner natural gas dryers much earlier. Is that in play if nuisance involves the reasonableness of the interference?
Absolutely. The course of conduct by GPC, it's operating for years, a rundown, high-polluting plant, highly profitable plant in the middle of Muscatine neighborhoods, emitting noxious smoke, odor, and haze that it knew was disturbing the neighbors with virtually no pollution controls, is a is an aspect of the case. It's a significant aspect of the case. And under Legg, Your Honor's most recent class certification decision affirming a decision by the lower court to certify, Your Honors indicated that when common questions represent a significant aspect of a case, not every significant aspect of the case, then there is clear justification for handling that case as a class action. But
Does it make sense to put on that same evidence over and over and over again?
in 4,000 trials, it would be expensive. It requires experts. It requires technical analysis. The experts, I don't believe one could get an expert to show up for 4,000 trials or even 2,000 trials with two plaintiffs each. Very expensive, very cumbersome.
Counsel, you've tried some cases. What's your best judgment as to the amount of time, the duration of the liability side of this case?
We believe that the course of conduct part of the case will take, I'd say, a week. Experts, GPC witnesses, demonstratives, analysis of air modeling data. The next stage, which is also common, it's not just the course of conduct, but we've also got common proof of the class-wide impact of the case. And by class-wide impact, I refer to the fact that impact was properties throughout the class. This is a different thing from saying that every individual class member was harmed. We can prove the class-wide impact through the scientific evidence. Again, expensive, time-consuming, complex and the idea of presenting it to multiple juries in thousands of cases is not attractive.
Let me ask this question. Mr. Reck suggests there's some due process issues, and I think he's correct in that although generally we give the district court discretion in class certification, if there's a constitutional problem, that is de novo review. I mean, I buy that part of his argument. I assume you do too.
Right.
So why don't you address his due process argument, the suggestion that persons will be adversely affected without a fair opportunity to be heard. He criticized opt-out procedures, you know, and we all experience, I mean, I don't know, in my IRA, I get opt-out procedures from time to time, and I don't know how much that cures anything. You get the fine print, and, you know, but, so why don't you address the legal issue of due process that's been raised?
There is no due process violation. Due process is notice and opportunity to be heard. And as this court approved in Anderson Contracting in 2009, the court upheld an order certifying a class of hundreds of thousands of Iowa consumers without requiring them to prove that each individual was harmed by the defendant's conduct at the class certification stage or even at the trial. It did require class members to prove that they were harmed individually, and this is different from the class-wide scope of the harm. This is the individualized proofs of harm, which you find typically in every class action. In the post-trial claims process, the class member has to come forward and has to establish eligibility in the class and entitlement to relief. In other words, the fact of that individual class member's harm.
Counsel, that's easy to do if it's just math. You know, when did you buy the stock? When did you sell it? You know, how much were your utility bills and the franchise fee you paid? But isn't in this case going to have individual trials, house by house, on the amount of damages?
It might require. It is possible that it will. We believe it will require the class members to establish, I lived at this property. We're going to have a damages formula that assigns to each property a damages total. It'll be a 7-year damages period total. So to collect any money, a class member will have to come forward and say, I lived at one of these properties. This is the property I lived at. Here's how long I was there. The nuisance bothered me. I was individually harmed by it. We will already have established that throughout the class, the conditions largely similar satisfied the normal person standard under Iowa law.
Does this happen in some sort of administrative phase?
That's what Anderson says, Your Honor. In Anderson,
could there be cross-examination?
Yes, I believe if the court, it would have to be designed, but the challenges to these claims are what give GPC due process, and we do not dispute that GPC would have an opportunity to challenge these class members' claims when they come forward. In Anderson, the court acknowledged how difficult it was going to be for each individual class member to show harm. The reason in that case was, and that was an antitrust case, a price-fixing case, was that the product at issue that was overpriced by the conspiracy of the defendants was a rubber compound, a rubber, what do I call it, a rubber, synthetic rubber material that was used in a wide variety of products, appliances, roofing tiles, all kinds of different products, and often combined with other compounds in the use in those products. So what the court said was that virtually every consumer in the state of Iowa was a member of the class, or was putatively a member of the class, and in order to claim damages, they talked about hundreds of thousands of mini trials. This was the defendant's number, but the court didn't give the court pause. Hundreds of thousands of mini trials at which it would be very difficult for these class members, the court said, to determine that they had purchased any of the wide range of products that contained this synthetic rubber. Not only that, but also that the synthetic rubber in those products that they had purchased was originally manufactured by the defendant. This was a extremely challenging, but the trial court said, but not insurmountable problem. But that was, they didn't describe thousands of mini trials, they described them as mini trials, and they numbered them at the hundreds of thousands. And that did not deter the court from affirming the trial court's determination. This court said in that case that as long as the district court weighed and considered the factors and came to a reasoned conclusion, we will affirm. Due process is about the right to assert defenses. GPC will have the opportunity to assert defenses in many different respects. We haven't gotten to the merit stage of discovery yet. We haven't identified our witnesses for trial yet. But any witnesses we identify for trial, GPC will have the opportunity, if it wishes to do so, to depose them. GPC will have the opportunity to cross-examine our witnesses at trial who are going to be testifying around the class to the impact of the pollution and the fact and their experience of it as offensive and seriously annoying. GPC will be able to examine them about their moving to the nuisance or not. GPC will be able to engage in discovery subject to the court's approval if they can demonstrate a need to present their own witnesses, counter witnesses around the class. Maybe they can present witnesses who say the nuisance, the pollution didn't bother me. Maybe they can do that, maybe they can't. So far they haven't come up with too many. They've come up with 7 to our 85, 90 witnesses who say otherwise.
All right, Ms. Siskind, you can sum up your argument.
Due process is an opportunity to be heard at the post-trial period. GPC will have an opportunity to assert its defenses. The fact that the process is less convenient for GPC, not the process it would choose if it were bringing the case, does not amount to a violation of due process. The judge was thoughtful. He exercised his discretion within the rules. We believe the court should and will, given its precedence, should affirm that decision and that there were no legal errors or constitutional violations that would prevent that. Thank you, Your Honors.
Thank you as well. Mr. Reck.
I would like to correct one mistake that was stated. It is not correct that we have not gotten to merits discovery in this case. In fact, discovery was not bifurcated in this case, nor was this a class certification motion in the infancy of the case as the rules anticipate. This case is 5 years old. They had ample opportunity to find witnesses, and yet we are still in a position where we don't know who those individual witnesses are that are going to prove liability in those areas with fewer emissions. That is alarming to us. It is also alarming to hear that we will be able to then call witnesses throughout the area to rebut them. Your Honors, how am I to identify those witnesses? Am I to call their neighbors and say, what was your experience? I can't. They're all represented by Ms. Siskind, because we have certified a class without identifying who the class representatives will be for those smaller areas. What am I to do? That does indeed deprive GPC of its due process. But, Your Honors, something else is happening here. Every time we get together, there is an ever-expanding post-trial proceeding in which our due process rights will be observed. Now we are told that we are going to be able to examine all of these witnesses about whether they were affected on their properties. Your Honor, to answer your question, Justice Waterman, where is the efficiency in that? We are going to have to call every one of them again and say, when did you arrive at this property? What did you know when you arrived at this property? Were you like Ms. Boiselle, where you got a really good deal on your property and you intentionally made a trade-off? That's what she did.
Well, but there might be some efficiency if the general liability question has been determined, namely that the technology was substandard and all the allegations. And if they make their case, we won't have to go over that. We won't have to have the experts, the battle of the experts. I assume you're going to have experts saying, well, it was unreasonable or impractical or whatever. We won't have to have that in these little mini trials, if you will, on damages, I don't suppose.
So I guess, Your Honor, the question I would have for you is, let's say that GPC should have replaced Dryer House 4 sooner. What does that prove for liability at 2209 New Hampshire Street, right? Because at its core, nuisance depends not on what happens at GPC, but on what happens to that individual living at their property. And it is not simply a one-element case. That's where, when you look at other states, coming to the nuisance is often an affirmative defense, right? And there are courts, some courts say that's too much, you can't certify with that affirmative defense. Others say, oh, that's an affirmative defense, you can handle that post-trial. Here, it is one element of a multi-part balancing, all right? So in terms of our operation, if you call that the reasonableness of our operation, that's one fragment of what they would have to prove. What then are we going to do in that post-trial proceeding? You take that one fragment, and even then, Your Honor, let's think about that. Dryer House 4 has a different radius of effects that it could have, all right? So you have to know what emission is going to, what emission is going to reach every single property. Because you have to say, was that machinery operating reasonably, but did that cause an emission on your property? Because if not, then how are you going to prove liability from that improperly running piece of equipment?
No, you might, conceivably, you might achieve that. I'm trying to project the future, which is always challenging. But you might be able to show that their class claims, in fact, collapse on the merits. I mean, you might be able to show, well, you know, it was Dryer 4, not Dryer 5, and the smokestack was over here. Or, I mean, I don't know what the layout is, but I can conceive that you might be able to show at trial, or even before trial, that this class theory just doesn't hold, and then you decertify. But I guess we're not really at that stage yet, are we?
Well, what I would say, Your Honor, is Carrera is one of the cases upon which we rely from the Third Circuit Court of Appeals. It is a due process case. And what Carrera said is, it is not acceptable anymore, after all the Supreme Court opinions that have been coming down, to say, maybe it will work out in the future, that maybe they'll find a theory. You have, I think in some ways, if we go through what you've asked, you've posed the question very well, because it highlights what they're going to have to do in that post-trial proceeding. You could take one fragment, but you're still going to have to add that into the mix of all the individual circumstances on each piece of property. I think it was Justice Mansfield when he was on the Court of Appeals, and McGinnis said it can't just be a thread, a common thread. It has to be a common issue that actually drives liability. That's what Walmart versus Dukes tells us. There is nothing in proving that Dryer House 4 ran improperly that proves liability at 2209 New Hampshire Street. It just doesn't.
If we decertified the class and this litigation then involved a series of individual trials, if GPC lost, would that be issue preclusion that would save time in the next case?
We would certainly argue that, Your Honor, that if it is found by a judge particularly, and Justice Mansfield, you were asking what we regard as one of the critical questions. Are they admitting that they all knew and they all accepted that trade-off when they moved to the neighborhood?
They're close to that.
They came pretty darn close, but that is a curious thing, isn't it, Your Honor? Shouldn't they, as the people trying to represent all the individuals, be fighting really hard against me on that?
They conceded. I mean, gee, a plaintiff's lawyer, I mean, when you're on weak grounds, you usually concede. You're better off conceding than fighting usually. Go ahead.
But Kelsey Brackett doesn't. Kelsey Brackett does not. Kelsey Brackett says, I didn't know. And the depth of the knowledge and the amount of the knowledge and whether you, for example, let's go to the
Won't
Gorhams.
Kelsey have an opportunity to opt out of the class?
Kelsey's a class representative.
She's opted in.
He, but
He, okay,
yes,
he,
yes.
There
But
be
let's,
differences also as to some people might not have purchased their home. They might have acquired the home by another means. So
that
they
is
might be in a
absolutely true.
different position.
And further, let me give you another example, the Gorhams. The Gorhams rented their property for some time before they made the decision to purchase. And in fact, they testified that they purchased for less because they knew it was an industrial neighborhood. Not everybody is going to have that fact. For those, all of us have tried cases or heard cases, right? Would I at least be able to admit that before a jury? I don't, as a trial lawyer, I don't understand how the answer is no. I cannot get my mind around that. I don't think any of us could. If a judge did that to us, we would be having a conniption, right? How can I not say that they got exactly what they were looking for? Because that's a Kroll case. The only directed verdict where the court said, no, you can't prevail, was that fact, right? Why can I not admit that Becky Boiselle knew exactly what she was getting into, more so than anybody else? And why can I not explore whether you personally knew what you were getting into for every single property? And does that add to the balancing? And if it's part of a balancing where there are multiple factors balanced, finding one factor does not determine liability. We've talked some about damages. That's not what we're talking about. We're talking about liability. But more alarming still, Your Honor, is you're sort of assuming something that the district court did not. And they're implying something that the district court did not. That we will have a post-trial proceeding on damages. Seems intuitively obvious to all of us here, but that's not what the court did, despite the fact that they cannot even show emissions that are perceptible class-wide. They are going to take a concentration total and divide it. If you are at 50 and somebody else is at 100, the 100 gets $1 figure, the person at 50 gets 50% of that dollar figure, and you are going to do that whether the 50 is perceptible or not. That has to be a due process violation. Has to be. But that's what the district court did. And that's what's improper. Is it efficient? Sure is. It sure is. But that efficiency trammels somebody's rights. And because it's my client, I object mightily. I've gone way over my time again. You've certainly kept us on our toes today, which I regard as a compliment. Thank you very much for your time and patience.
Mr. Reck, thank you as well. The case of Freeman versus Grain Processing Corporation is now submitted, and we'll next hear the arguments in State versus Shorter.